All right, so let's go ahead and get started. And in terms of the format, each of our panelists has been asked to give some thought to a particular question that pertains to their research. And then I'd like the other panelists to sort of chime in. You'll have maybe 10 minutes to react to your colleague and be able to ask any questions of them or, in fact, weigh in the conversation. So let's get started with Professor Ohm. You've written a lot about the power of data inference and how it changes privacy law. And one of the examples I can give is an article you actually did about 15 years ago, which talks about how analysts can re-identify supposedly anonymized data. I'm wondering how the advances in AI over the last 15 years has maybe changed your thinking on the problem of inference, if at all. So go ahead and get us started.
Great. And should we just stay in our seats? Is that simpler? Or?
It's totally up to you. You're welcome to come.
I'm gonna keep it here.
Okay.
So thank you so much. I think the morning has already demonstrated that there is some magic being had today by bringing together these two kind of preeminent centers. For those who don't know, I spent my first 9 years as a professor on this faculty, and I was one of the first faculty members that Attorney General Weiser hired to join the center. And now that, with the distance of time and I'm at a different place, I do recognize that Flatirons and the White Center are two of the preeminent centers in the country, and they do things on a different level and they have more impact than almost any center I can name. And so the bringing together of them for the first time seems like an auspicious occasion, and it seems so appropriate given how important these issues are. I will also note that I can't believe I'm the first person to want to call this the Flat White Conference, because it joke that writes itself. So that's what I'm going to think of this for the rest of the time. Newton Campbell is here from the land of the Flat White, and so it seems appropriate. Okay, so what I'm going to talk to you for 7 or 6.5 more minutes about is actually a general point. So I think it's appropriate to be the first panel discussion of the day that will frame hopefully some of what is said on this panel, but maybe on other panels throughout the day. Because I have been thinking throughout my career, if you want to kind of crystallize or distill what I'm thinking, about arguments that recur time and again with the advance of technology as we think about what is that technology doing to our legal rules. And so I will get to privacy as an example of this, but let me name one style of argument, and I would love to talk to the Colorado Law Review about possibly publishing this as a kind of small contribution. I think of this argument, I need to come up with a pithy name. For now, let's just call it the AI style of argument, as an argument in 3 steps. Step 1, and this is going to sound familiar to all of you no matter what field you're in, the law, and sometimes really ancient law, focuses on a particular kind of fact pattern, a particular organizing principle, a central form of reasoning. That's step 1. Step 2 is what Professor Surden's masterclass talk was all about. Technological advances put pressure on that fact or that fact pattern or that organizing principle or that central reason. But it's step 3 that I really want us to focus on. Step 3, many people say, well, given that the law has just been subjected to pressure by the technology, the law must yield. We need a new type of fact pattern. We need to reorganize the way we think about analyzing that type of legal question. So let me give you 3 quick examples. I'm going to end with the one I want to focus on for now. So think about intent, right? Intent is a well-worn kind of precept in many, many, many legal provisions. Many laws say that only human beings, and that's really important, who take certain actions, but not only actions, but with particular intent, are civilly liable or criminally culpable. Just to kind of, put meat on that bones, the securities law says certain forms of intentional market manipulation are illegal, and intentional does a lot of work in cases like that. It's a defense to an investigation if you can say, this was accidental, I didn't know as a human being that this is what I intended. However, now that artificial intelligences trade stocks, the question of whether they acted with the requisite intent, if they did all of the other things required for market manipulation, is either like philosophically, less than straightforward, and it might even be argued that it's completely nonsensical, right? So you have a smart stock trading bot, you say go maximize profit. It may take steps that, if taken by a human, would clearly be illegal, but has the AI violated the law? Has the human who kind of trained the AI violated the law? So step three again is what I'm hoping to push back on, is let's rewrite market manipulation law. Let's find something other than intent to replace what the intent used to do in that role, right? And that just seems like the natural response. Okay, let me give you a second one, and this one is familiar to what many people in this room have written about. We have a lot of laws that focus on not only the decisions that are made by a decision maker, but why they made those decisions. So many legal notions of fairness require the decision maker, when they hand out their decision, to say, here is why I am saying yes or no to your request. Professor Goodman, for example, has written about due process law. Due process law has this old set of elements attributed to Judge Friendly about what it means to make a fair decision. And one of the things in the very long list is a statement of reasons. That's step one. Step two, can't do this with AI. AI is a black box system. It is an opaque decision maker. Many, many, many people in this room have written about the problems of interpretability and explainability, not just with neural networks, but with older forms of machine learning as well. So the hypothetical is state government has a computer program based on an algorithm. It is deciding who gets Medicaid benefits. Those of denied benefits, they may never know why. They may never get an accurate explanation for that decision. Not even the designers of the system can give them an accurate explanation. Step three, let's redefine the constitutional definition of due process. It used to turn on this notion of giving reasons. We now have magic machines that cannot give reasons, so we rinse and repeat. Okay, I'm an information privacy scholar, which means that I focus on constitutional and statutory rules that protect people from harm due to the collection, use, and sharing of certain forms of information about them. And many of these laws are premised entirely on defining categories of information. Not all of them, but a lot of them. Let me give you three quick examples. HIPAA, the Health Information Portability and Accountability Act, it governs this critical definition, health information. The Colorado Privacy Act, wonderful state privacy act, and full disclaimer, I helped write the regulations around this act, although I am not speaking here on behalf of anyone, probably not even myself. It defines a series of rules that one must take for all pieces of data, but particular special heightened rules for quote unquote sensitive information, racial or ethnic origin. I'm just going to read some of them off. Religious beliefs, mental and physical health condition, sex life, sexual orientation, and citizenship. And then if you want a constitutional example, because I do write quite a bit about the Fourth Amendment, of course, protects information for which we are entitled to a reasonable expectation of privacy. And the Carpenter case has recently said that forms of data alone may support that kind of conclusion. That's step one, right? We define categories of information. Step two, one of AI's oldest known powers is that given fact A about a person, I can infer fact B. If I know what groceries you are buying, I probably know your religion, and I probably can make some very educated guesses about your health condition, right? Because of the foods that you're choosing and the foods that you are avoiding. And so because this is the step two pressure on law, I can infer that you have celiac disease should your shopping list be regulated by HIPAA, because I can infer that you are an observant Muslim should the sensitive information rules of the Colorado Privacy Act apply to those rules. And then a well-known example that's been debated a lot recently, because I can infer from your cell site location information that when you went to a particular place, you visited a Planned Parenthood location, does the Fourth Amendment protect that data? So now we know what step three looks like. Step three says, well, because of AI, everything now reveals everything. We need to throw out that old way of protecting privacy. We need to stop defining laws that treat some pieces of information different than other pieces of information. This is not a straw man article. I am writing a much longer article than the one. Colorado Law Review would never want to go near this one. It's big and sprawling and messy. And in it, I'm taking on one of the most respected, preeminent information privacy law scholars in the country, also a good friend of mine, your colleague, Daniel Solov. Solov has an article, and even the title gets my blood pressure going, called Data is What Data Does. And Dan argues, quite unpersuasively, I might add, that due to this power of inference we just talked about, we should just stop writing privacy laws like this. We should get rid of the notion that we have health laws and that we have sensitive information laws. I am going to spend a lot of time explaining to my good friend Dan why he's wrong, but I just want to focus just on the nature of the step 3 move, which Dan is making. Embedded in step 3 is a value judgment about the malleability of law, the malleability of technology, and what happens when those two collide. I think that too often people making the step 3 move, and too often people in general, treat technology like it's the fixed part, the part we cannot control and the part we cannot change. We almost naturalize it. We treat it like it's something that evolved. I'm so annoyed whenever someone talks about AI or technology evolving. It doesn't evolve. People, create what it does. More defensively, some people who are legal scholars might be saying, I don't know if technology can be changed, but I certainly can change it, right? That's a little bit more defensible. That's about institutional competence. That's about letting people do what they do best. But more perniciously, there's just this technological determinism, the idea that, even though, yeah, some humans are involved, technology just happens. It just marches. It just evolves. And on the flip side, I'm going to say less about, because you understand how we think of law. Right? Law is something that we fight over, it's contested, we have politics, we have rules, we disagree, we chart the progress of it over time. And so it's no wonder that step 3 has so much allure. When you have the fixed deterministic vision of technology, like today's large language models, versus the pliable and malleable, very social thing that we call law, well, of course, law has to yield to the imperatives of technology. And I just want to rebut that. I want to rebut that for sensitive information, right? But I want to say that, at the very least, let's double down on sensitive information laws, and let's build into our definition of sensitive information laws this power of inference. So the Colorado Privacy Act, again, I helped write the regulations, it's not just your religion, it's data that reveals your religion, right? I think that's a pretty neat fix, at least until the day when AI means that everything literally does reveal everything. But to end my talk, let's not stop with sensitive information. Rather than reshaping securities law that accommodate robots that manipulate markets, why don't we just ban robots from trading on the stock exchange? Rather than reshape due process rules so that we find something other than explanation to tether our due process rights to, maybe we just tell states they can't use AI to dole out Medicaid benefits if they don't understand why it's making decisions. I don't harbor illusions that all of these arguments are going to succeed. March of technology is super alluring. People treat it almost with this near religious zeal. I just want to push back on arguments like these. Thank you.
Comments from your colleagues?
So as GW's a non-privacy person here, I certainly can't adequately defend Dan. I do have a question, though, in terms of your intent example, Paul. I am concerned, at least in the context of discrimination, whether it's constitutional interpretation, statutory interpretation, et cetera, about the heightened focus on intent. If you look at, for example, interpretations of Section 2, which is really an effects test of the Voting Rights Act, where there's kind of almost a trend to kind of cut away at Section 2. And so what does your take with regard to intent mean with regard to the future of AI and discrimination?
Yeah, and I'll confess with apologies, I haven't read your recent contributions on this, which you've distributed recently. I'm also not an anti-discrimination expert. To be clear, I think there is a debate predating the rise of artificial intelligence about intent in anti-discrimination law versus just pure disparate impact. And so I don't mean for my intervention to have anything to say, much less disrupt that debate. Insofar as I've thought about it, I think, having a rule that says something that has a very, very, very disparate impact should be a violation of the anti-discrimination laws, whether or not there's intent. So that's where my vote would be. My vote would be for, my point is for laws where intent is doing some really useful rule that isn't so in debate, we shouldn't ditch intent just because the robots can't intend. So I don't think I would actually use that as an intervention in your debate, but it's really important for me in this essay, if I write it up, that I need to clarify that distinction. So thank you.
Thanks. Can you hear me?
Yeah.
Okay. All right. Thanks for your comments. And my question is addressing if you want to double down on the privacy laws and on sensitive information, then are we going to get in a situation where, because certain groups aren't well represented in the data already, and more data will be kept away from the machines, that they will actually become less accurate?
Yeah, I mean, that's a much, much bigger and difficult fight we can have. And I feel like we agree on lots of it and disagree on lots of it, but it is true that privacy law sometimes, when it operates well, and sometimes when it is used cynically by people, can be used to get in the way of things we want to do with data. For sure, 100%. That's almost, to me, tautological, that sometimes if you really, really believe in privacy, it means understanding that there will be costs, including things that we really might care. So if, you know, a privacy law is standing in the way of making a biased machine learning algorithm less biased, I want to have that debate. Like, that might be a great candidate for an exception, or it might be that I'm able to persuade, you know, other people that the privacy interest should be stronger. But you're right.
But it's that balancing privacy
It's that
and
absolute
fairness, right?
Yeah, I mean, being a privacy person means you're super unpopular among statisticians, librarians, historians, right? People who really believe that, like, data is this kind of, you know, thing that we should never inhibit any access whatsoever to. And so I think it's the burden on all privacy scholars to make sure you're super nuanced about the harms you care about, you know, the reshaping of society you're trying to prevent, to justify what are really deeply felt beliefs on the other side about data. So.
Thanks. Do we have time?
Any other comments?
Yeah, I'd love to.
Yeah.
Paul, thank you. I mean, I totally agree with you that we need to make the tech yield, not make the law yield.
Yeah.
I'd like to hear a little bit more about how that plays out, because I think that in some contexts, and I'll talk about this a little bit later, like the starting point, the anchoring point for certain legal interventions to new technology has been like moratoriums or bans. And that's generally where I align myself. But one thing I'm concerned about is that too often that may be the starting point, but we end up accepting what I would characterize as sort of Band-Aid regulations that in the process legitimize the technology and really don't address the myriad privacy harms and equitable harms that you're concerned about. And just as one example of that, I mean, I think body cameras are an excellent example of that. Like, body cameras are, in my view, a pernicious surveillance technology that have a disproportionate evidentiary surveillance impact on communities of color and queer people. And yet, they've been accepted, and we're like, oh, well, as long as, you know, access is regulated, as long as, you know, we control when the camera is on and off, the technology is acceptable. And I think that once we're in that debate, like we've lost, like it's legitimated, and now they're everywhere. And so I'm interested to hear more about how you envision us at step 3, calibrating those two.
Yeah, and I'm gonna focus specifically on sensitive, just because I've thought more about it. So I have an unsatisfying response, and then hopefully a more satisfying response. The unsatisfying response is, in my longer article on sensitive information, I really want to separate the question Dan takes on, which is, should we even treat some data differently than others, from the next obvious question, which is, okay, once we agree to do that, what extra rules do we put on the sensitive? And I feel like that's more your question, right? Is it a ban? Is it a moratorium? Is it a toothless risk assessment? Is it somewhere in between, right? And so I'm just defending the category. I want to have a longer fight then about that. But I'm totally sympathetic, I think, to what is the thrust of your question, which is, it's not enough to kind of build tiny guardrails around the use of a technology. I'm completely dedicated in other parts of my agenda to thinking of democracy as a force that can redesign technology itself. I mean, it does anyway, whether or not we intend it. But I would love to see, and let you First Amendment people on that last panel come at me about this, I would love to see government rules and regulations that are intended to literally say, you can't run a, you know, body cam technology that works like this, you have to add this, and force them to go back to the drawing board and redesign their products, right? So I hope that's a little more of a direct response. So thank you. Thank you all. This was really helpful. Appreciate it.
Thank you. All right, we're going to move on to the next speaker. I would like Professor Overton to take on the question. In the context of democracy, most popular discussions about AI involve deep fakes. Why is data privacy relevant to AI and elections?
Okay, thank
us
you
out
so
there.
much, Professor Malveaux. And you know, it is an honor to be here. Again, I'm not a privacy person. I'm a democracy and race person. I really didn't realize or appreciate privacy in this context until I wrote a couple of law review articles. One about platform liability for deceptive practices in the voting context, right? And this more recent one on the potential harms of AI for democracy in terms of racial harm. So for example, in terms of kind of last generation stuff, you know, we think about social media, the business model, collecting data, building a profile on someone, delivering ads, and the Russians in 2016, right? Basically creating pages and ads, pretending to be African American, you know, talking about social justice, and then right before the election saying, hey, let's boycott this election, let's stay home. And in terms of the Russians' ad spend, even though black folks are about 13% of the population, they accounted for about 38% of the ad spend by the Russians, and they were about 50% of the user impressions here in terms of the ads here. So now new forms of AI, emerging forms of AI and data, right, can take this to a new level because generative AI is easy. You know, it's easy to create more content, to generate more content quickly. You can create more persuasive ads that can be more customized to smaller audiences. Audiences like black males ages 18 to 25 in Philadelphia here, right? And in the future, with current trends, we may get to the point where we're collecting individual data and designing ads, kind of processing, designing ads tailored for the interests of particular individuals here. The bot of the black congressman who has a video conference with a constituent and pretends to talk to them about their individual interests and know them. And then at the end says, hey, these Democrats are taking us for granted. We really do need to stay at home. That is a possibility. It might not even be explicit. You could have an AI that kind of understands your interests and basically just gives you a lot of sports and entertainment and diverts you from thinking about politics and distracts you or a particular targeted audience here. That's a possibility. And I know some of the big platforms have guidelines in terms of political advertising. I know the EU AI Act bans cognitive behavioral manipulation of people or specific vulnerable groups. But this future is largely unregulated right now in this use of data in the US. Another example, and Professor Skinner-Thompson is going to get into it more deeply, is just this law enforcement, AI-powered tools that analyze cell phone data, social media feeds, closed circuit TV images, and facial recognition technology to basically surveil without a warrant, Black Lives Matter protesters, dreamers, folks like that, and their allies, and really kind of chilling speech. This is now low cost, so there are a lot of local law enforcement departments that can use it with very little oversight. And like I said, he's going to talk about it. I'm not going to get any deeper into that. Finally, another example, politicians using AI to create new voter restrictions. So we know that machine learning's been used, algorithms have been used for years to draw gerrymander districts, right? But politicians have been pretty clumsy in terms of voting restrictions lately, right? So they basically say, hey, let's end early voting on Sunday. Okay, you know, the souls to the polls in the black church is pretty obvious what's going on here. It's kind of clumsy and obvious, right? But you could definitely see a Secretary of State whose party is supported by, let's say, 80% of whites and is opposed by supported by 60% of whites and opposed by 80% of people of color, basically using machine learning and basically looking at voter files, not just voter performance, but also your supermarket bonus card, kind of what you're buying when, your TV viewing habits, that kind of thing, and determining, hey, most white folks on Wednesday, they go out and they do their errands, and on Tuesdays, they stay at home and watch their favorite TV shows, and the reverse is true for people of color in terms of days. So we're gonna move those late early voting hours that go from 5 to 8 in the evening. We're gonna move this from the current day to a day where white folks are more likely to be out doing their errands and people of color are more likely to be home watching TV. And you do that, and in the next election, you know, you see a slight uptick in terms of your voters and a slight decrease in terms of the voters who would vote against you, and your party has some benefits, and no one knows what's going on. It's not a souls to the polls type of Sunday voting type of thing. No one knows. So these are all very real possibilities here. Anita Allen has an essay on how data privacy uniquely impacts people of color generally. And I would just say that because race is the most significant factor in voting performance, more so than other demographic factors, and because politicians have an incentive to win an election, data privacy has unique implications for people of color in the context of democracy.
Thank you. Comments? Yeah.
So I want to just push back just a little bit.
Yep.
You talked about the horrors of, you know, for democracy, but what about AI for good in democracy? So one thing that we've been thinking about is how do we get more people to choose to run for office, those who would be the politicians that would be more representative of our interests and those sorts of things. So how do we use AI to select before we get to the polls and have to elect from candidates that aren't of our choice?
Right. And I'm going to do a piece for the Colorado Law Review on some of the benefits of AI generally. My last piece was on harms. I think specifically in this data privacy context, there are some good uses. You know, one like is mobilizing voters. Basically, black voters are maybe about 10 points behind white voters, maybe 5 to 10 behind white voters in terms of turnout, with Latino and Asian American voters. I'm talking about CVAP, citizen voting aged folks. It's about 15% lower here, right? So basically, if you can use data to mobilize folks, I think that that's a good use to kind of boost turnout. Identifying the common interests of different communities. So if we have these kind of cultural markers that kind of divide us, but there are some real things that actually unite us, but they're not out front in identifying those things and bringing folks together, allowing politicians to hear from underrepresented perspectives. You know, those are, I think, great uses. So definitely there are good uses of AI and data, and we've got to navigate this space to figure out how to maximize those good uses while also mitigating the harms.
Great. And I just wanted to follow up with that because you mentioned the EU, and I'm wondering if you have some models that you're thinking of either coming out of the EU, coming out of history. You said, you know, this isn't the first time that this has happened, or even states. Are there models that you would be attracted to?
You know, I think that, and you all know this, may know some stuff that I don't know, but I think a lot of states have focused a lot on like deep fakes. They focused on, you know, kind of deep fake porn, some of these issues here. In terms of using data, you're gonna know this better than I do, to kind of manipulate people again, it seems like the EU, they basically, as y'all know, they categorize uses and they base regulation based on the use. So this, psychological manipulation would be banned, whereas let's say a deep fake is just going to require disclosure and transparency, right? So this is their highest level of regulation in terms of a complete ban, and it doesn't seem like we're doing much about this, but you may know something.
It's a good segue into the question I wanted to ask you, which I think is another version of the benefits versus. So a lot of the restrictions you're talking about in the GDPR and the AI Act are use restrictions, but they don't necessarily get in the way of the collection. But there are other parts of the GDPR that, for example, they're using against Facebook right now, which credibly might say to Facebook, you cannot do behavioral advertising anymore. You can't collect the information. And one thing that I've always seen, trust me, this will become a question in the end, is that I have colleagues who are really, really upset about micro-targeting for advertising, but they're also dedicated political junkies. And they love the efficiencies of knowing exactly where to target your last dollar and your donor's money. And so they don't want to throw out that baby with that bathwater. They want to somehow say, cut it out for ads, but keep doing it for campaigns. I'm much more extreme. I'm like, let's just dry up that market altogether. It'll make our elections less efficient, but it will have all of these downstream benefits. I suspect it will also take away from some of the benefits that Professor Goodman talked about. What do you think about that? Like a just flat ban on this sort of behavioral targeting? And you can't just say that will never happen.
No, I won't. I will say I really am nervous and concerned about good uses in terms of mobilizing, this disparity in terms of voter mobilization and turnout. I mean, I think that there are some really good uses. I mean, if we think about things like, who's susceptible to sickle cell, right? I mean, there are a variety of, I think, beneficial uses in terms of these tools, and simply because some folks are using them for nefarious purposes, I don't know that we should just outright ban them, right?
Great. Other comments?
Well, I would just add, I mean, one I think is super interesting, and I think I share your reaction. One, I have, as the earlier colloquy with Professor Ohm illustrated, like I'm deeply skeptical about most of these technologies. I'm also worried about law's ability to catch up. But in the context of certain technologies, including behavioral advertisements and the like, whether pernicious or advancing important democracy concerns, I actually have more faith in people to solve some of these problems than the law, which is to say that despite, ChatGPT-4's intelligence, I still think we're pretty smart and savvy. And yes, the deepfakes and whatnot and the manipulation has an impact, there's no question. But I also think that we as consumers of technology and consumers of information, we have gotten pretty savvy too, like at realizing when we're being pushed, nudged, or cajoled in a particular way. And so this is one area where I think that with prolonged exposure, we as people using our intelligence will solve some of these problems.
I think that that's probably right. I think my concern with that is just a take is it's these unsophisticated people, it's them, that they're not sufficiently digitally literate, and therefore if they just put in more work, I think some of these things in terms of deepfakes, other things, I mean, when we talk about ad delivery and you don't know who's getting what, there's no way that someone understands what's behind it. So I think that you're right that we will become more sophisticated, but I don't think that that's a reason to say law does not have a role to kind of contain or mitigate, right, some of these challenges. I also think that getting back to this other piece about outright restriction. You know, this lower cost piece is a big deal, right? The fact that if I'm advertising, I don't have to spend a commercial in a metro area and try to hit everybody, but I can just kind of target and focus is huge. And I think that there are definitely some tough cases, right? Like, so for example, what if I bought an ad that basically said, hey, we're gonna covertly reduce anti-Black bias. And we're not gonna be blatant about it. We're gonna we just know this ad that has nothing to do with race, right? It reduces anti-Black bias somehow. I think that that's a tough case in terms of people being manipulated, even though I would say it's a good purpose. So I definitely agree that there are tough cases here. Finally, one concern I have, and I'm shifting back, is this notion that we're all going to get to the point where we don't trust anything, right? Like, hey, you don't, and I know you're skeptical. I definitely get the body camera thing, but the person who's skeptical of the onlooker who records police violence because that might be a deep fake. And normally, if I think it's real, and I'm kind of like an average white person, I'm like, hey, I appreciate humanity and respect it, and let me go out to this Black Lives Matter rally. But if I think this is a fake and I'm just being had because I'm sophisticated here to a point, right? Then I might just say there are other things for me to do. That might be a deep fake. This might be somebody pulling my leg, let me go home. So I am concerned about that development to a certain degree.
Great, thank you. Let's shift ourselves to Professor Skinner-Thompson. AI has already been deployed by the carceral system with significant implications for privacy rights, particularly for minority communities. Can you tell us a little bit more about those implications and some potential legal interventions?
Yeah, absolutely. And just before I get started, thank you so much, Suzette and Harry, for your entire Byron White, Silicon Flatirons, Flat White teams for bringing us all together today. So, I mean, on the theme of prediction, Paul sort of predicted the structure of my intervention. It's going to have those 3 steps, except for it's going to diverge at step 3, I guess. At least diverge from Dan Soloff. So my view is that, generally speaking, and building on the theme of the conversation, as it pertains to most technological advances, not just artificial intelligence and machine learning, carceral systems have been able to exploit constitutional rules that were developed without those technologies in mind. And there are lots of examples of this over the last century where carceral systems have been able to use specifically lax interpretation of the Fourth Amendment. Such interpretive rules include the notion that there's no right to privacy in public or no right to privacy over information once that information is shared with another individual, sometimes referred to as a third party. And so examples where the court has applied these old rules to permit the use of new technology include, for example, law enforcement aerial surveillance of people's homes, even within the curtilage of their homes, and surveillance of their properties from telephone poles over time, too. So it's not just one-off surveillance, but over long periods of time. There are, of course, counterexamples. It's not like technology always wins. The court has said using infrared technology to look inside someone's home is impermissible. And, there have been modest victories as Professor Ohm gestured to, the Carpenter case where the court required a warrant for law enforcement to access a historical cell site information from service providers. But generally speaking, as Professor Andrew Ferguson and others have aptly described in detail, current Fourth Amendment constitutional doctrine is ill-equipped to deal with law enforcement use of facial recognition technology. As Ferguson bluntly puts it, the Fourth Amendment will not save us from the privacy threat created by facial recognition surveillance. And this is particularly so under the current judicial qua political regime that is the Supreme Court. And my pessimism about this, I think, speaks to, again, to the broader discussion that Paul and I were having at the outset, is like, given technological advances, the poverty of constitutional law, like the poverty of democracy, like where are our and legislative and democratic interventions, where are we going to look to? And I don't know that I have the answer to that. And so, the lack of, and just to underscore, the lack of constitutional protections for privacy leave minoritized communities particularly vulnerable, given that many in those communities lack lived privacy, the precondition for legal privacy, and the fact that carceral systems are predominantly, surveillance is already predominantly targeting those communities. Moreover, as it pertains to facial recognition technology itself, as scholars such as Joy Buolamwini have noted, the facial recognition technology itself is built and trained on biased data sets that can lead to a disproportionate number of false positives for people of color. And in case you need more legitimization of that, research, I mean, the NIST recently confirmed the same outcomes. So how is facial recognition being used by law enforcement? Well, disturbingly, as the Congressional Research Service explained a few years ago in its report on FRTs, quote, the frequency and extent to which FRT is used at various phases of the criminal justice system is unknown, which should give us some pause. But some of the known uses are, one, the first is sort of what's referred to as sort of identity verification. And if you have TSA pre and you live in Colorado and you go to DIA, you've experienced this, which is where the TSA uses a face scan to ensure that the person presenting the identification is the person on the identification. So just verifying that the person holding the ID is that person. That is problematic in and of its own self, but they're much more troubling aspects, including, matching photos of suspects, okay, so you don't have an identification, to databases to identify the suspect. And those databases, some of them are built by law enforcement off of mugshot databases, which have its own bias, right? Or driver's licenses, which is huge data sets. And some of them are commercially built by companies like Clearview AI, just scraping social media posts. So sometimes it's used to match a suspect to figure out, to large data sets to identify who the suspect is. But other times it's just used, and this relates to political surveillance and what Professor Overton was referencing in terms of Black Lives Matter protests and the like. Sometimes it's just dragnet surveillance of public space to see who's there and if they're bad guy, right? And identifying people in real time.
Or if they're a troublemaker, right? Doesn't even have to be a bad guy.
Yeah.
Hey, you're against police or
Exactly.
or defunding the police.
Right. Yeah. Yes. Bad guy. Very inartfully and broadly defined. Yeah. No. It's absolutely true. Well, and it's predictive too, because they're going to make you a bad guy. We have this technology being deployed at scale by federal law enforcement agencies, by local and state law enforcement agencies. The Constitution, unfortunately, is a weak tool to deal with this. But and there have been legislative proposals to regulate it, all right? But I think that those regulations, consistent with my view of how the body cam debate has played out, are simply insufficient. So some of these proposed limitations include, limiting what's sometimes referred to as the probe photo, so the photo you're trying to identify who is in it, saying, oh, they can only be matched against mug shots. You can't match it against everybody that has a driver's license. That, we need to make the training data more representative so we have less false positives. The mugshot databases should be scrubbed periodically so that people who committed crimes a long time ago aren't identified, that real-time surveillance should be allowed. I mean, I think these are all good, but I think if implemented, it will just serve to do serve a legitimation function and won't really limit the overall surveillance harm of this. And that's why I align myself with Professors Woody Hartzog, Evan Selinger, and those in Congress who have called for banning or at least putting a moratorium on the use of this technology, using law strongly to make the technology yield. So that's where I come out on this specific application at step 3. And then just to link this back to Harry's chat a little bit, while I was talking, I asked, I'm not paying for this stuff, so I just used ChatGPT 3.5, the free version. I asked them, is the use of facial recognition technology by law enforcement constitutional? And, I've already been made redundant because it basically said what I said. It said, the use of facial recognition technology by law enforcement raises significant constitutional and ethical questions, and opinions on its legality vary. Facial recognition technology raises concerns about privacy, due process, and potential bias. Critics say leads to unwarranted surveillance, and the inaccuracies are noted. Some cities and states have taken the steps to ban it. Ultimately, the legality of facial recognition technology in law enforcement contexts will likely be determined by legal challenges, legislation, and ongoing debates about privacy and civil liberties. I was paraphrasing there a little bit, but that's basically what it and I said.
Good answer, right? I think you got it right. Spot on.
Sorry, who are we applauding for? I'm a little nervous.
Comments?
Oh, yeah, I can start. So you mentioned that while it would be a good idea if we were able to make the data sets more diverse so that maybe it would be more accurate, but what about encouraging people of color to submit more to facial recognition software, which would in turn help in the long run by making it more accurate, but also then make us even more subject to surveillance? And
I mean, I think it's a great point, and it's another example of the sort of privacy information trade-offs. Sometimes being obscured is of real value, and sometimes it makes you more vulnerable. And I think that they're ultimately value judgments. To the extent that the data, the systems, the FRT systems are coming up with false positives, that's deeply problematic. To the extent that they're coming up with false negatives for people of color, that's fabulous. Like, it's meaning it's not working. So I do think that is a tension that has to be resolved. Michelle Gilman at Baltimore, I think, has written, in my view, among the most persuasively on these surveillance gaps and for minoritized communities, and how, in certain contexts, the surveillance, particularly when it comes to government benefit programs and the like, they need to be addressed.
Thanks.
So definitely none of us like the concept of think of errors that are racially disparate, right? And obviously I'm very sympathetic in terms of the chilling, right, here. But let me just put on my DOJ hat for a minute here and basically ask you, there is this reality of limited budgets in terms of local police forces and law enforcement and tax dollars. there is this issue of innovation, and just like other areas innovate, we expect innovation in terms of criminal justice. There's a question of many human witnesses are inaccurate in terms of their identification, and that there's an argument that we could have technology that could be more accurate than some human witnesses here. And obviously, there are uses of technology like DNA that have exonerated some people who were wrongly convicted, right? So how do we allow for innovation in terms of technology in the criminal justice system? I definitely understand kind of selectively focusing in on erroneous applications, but what are the guidelines so that we say we're not Luddites? You know, in the criminal justice context, there needs to be innovation and growth, but here are the guidelines here in this space.
Yeah, I mean, thank you. I mean, I think it's a really difficult question, and I think I am sort of a Luddite at the end of the day. But you know, what I would say is I believe that, like, before law enforcement is going to use the technology, there needs to be at the very least a persuasive case made that this is actually needed for law enforcement to fulfill its duties, right? And to me, most of the time, in many of these examples, the technology is rolled out, right? Law enforcement is good at their job. I mean, crimes are, you know, and this is, again, I mean, assuming you're not an abolitionist, where I align myself a lot, but assuming that there should be robust law enforcement, like, they've been catching people and imprisoning them with some alacrity for some time. We don't have a problem finding people and putting them in jail in this country. Like, we do it more than anybody else. So, like, I'm not convinced law enforcement needs a lot of more tech to do that. And so if we're going to, if they're going to make the case that we need this tech to do our jobs, like, I think the burden has to them show that they're somehow missing something really problematic, and they need this tech to do this. I will say, in terms of use restrictions, when it comes to things like facial recognition, one of the use restrictions that I am perhaps most sympathetic to is the idea that law enforcement could, for example, use real-time video surveillance to stop an ongoing, mass attack, all right, but perhaps couldn't use that evidence in a trial, like for the purposes of punishment, but could use it as a means of thwarting the casualty. Well, because I think saving, lives is really important, but I'm worried about if the technology can use to, and hopefully there's other evidence traditional evidence they can rely on to, potentially pursue the carceral response, if that's where we as a society want to go.
Yeah, sure.
This is been such a fun panel already. It makes me realize I need to get out more often, because at all of the privacy conferences I go to, no one ever asks about useful data. We just assume that, that's someone else's problem. So it's good to confront it. I'll also say, for those who haven't read it yet, Brian Merchant's Blood in the Machine is a really lively retelling of the story of the Luddites and a comparison of it to the fight against big tech. And he frames the Luddites as like people who were being abused by, factory owners, and who rose up and actually had some substantive wins. So yeah, I too am a proud Luddite. Scott, my quick question, Neil McBurney and I were talking about this beforehand, is, in my understanding, NIST's latest report says they're still biased, but they're getting a lot better, and that they're building new evaluation mechanisms. And so I always worry about arguments that are based solely on the inaccuracy of machine learning, because in the history of machine learning, almost all of the algorithms just get better with time. Like, I almost feel like you gave us like the fact that mugshots themselves are inherently biased and problematic. That to me is a strong argument that's gonna last, as opposed to these algorithms are all biased, right? I think we may, in the near future, find out facial recognition is still problematic, but not biased anymore.
I think it's a really critical point, and I totally agree.
Yeah, okay.
So if I can just add one more thing. So you just brought up a point about if we let law enforcement use the technologies, but then prevent it from being used at trial, and that ties in right to Paul's step 3, right? We change the law a little bit. We can change the laws of evidence, make that another exclusionary rule, and then we would still get the benefits of both. And that way, tech and the law would be interacting, both, being, manipulated a little bit. But would that be a good solution?
I think that's a use limitation that I'm open to. But again, I think, well, one part of this is just like negotiation anchoring. Like you start with moratorium, but I will say too, I think that that aside, like because it's quite evident we don't know all the ways in which this is being used and the extent of its proliferation. But before we get to a concrete debate about use limitations, I think we need to just pause and then have that debate, not have the debate decades after the technology is entrenched.
Okay, great. Our last question I'm going to go ahead and pose to Professor Goodman. How is AI being used in hiring? What are some of the privacy concerns that arise in that context?
Well, thank you very much, Suzette. And again, thank you all for having us here and participating in this event today. So some of the ways that artificial intelligence technologies are being used in the hiring process are in creating position ads. You can use ChatGPT to create the ad for you, and then that ad will be disseminated to particular people, again, using social media and all of those things. Once that ad is disseminated, well, then you can use artificial intelligence technologies to screen resumes, to cull resumes, to figure out who are going to be the people that deserve an interview, for instance, the people who are able to get started. Once you do that, some companies are also using it to issue personality tests of some of the applicants. They want to see what are their strengths and weaknesses. Is this someone who's likely to do harm to the company or someone who's likely to help out? If the artificial intelligence technologies are then used to conduct video interviews, and they're evaluating your facial expressions. I have lots of facial expressions and talk with my hands. I don't know what they think about that or how that would be evaluated, but that's another round of screening. So through all of these levels, we're using artificial intelligence technologies that we've just learned we don't understand. We don't know what they're doing. We don't know what's going on. So that is, those are just some of the ways. So the concerns that arise from that is one that's already been mentioned. The data is retained. When I do that interview, guess what? 2 years from now, if I apply to that company, they've still got that data. It's still out there. Well, what if I've gotten better? What if I've, developed new skills? I'm already going to be subjected to, I'm already going to be tied down to the me I was 2 years ago. And I may not even get through the door. I may not even see the ad if the way that the artificial intelligence technologies created the ad was an ad that is not something women would like to see, or is not something that my social media feed, which I hardly ever read, would provide to me. All right, so I may not get the opportunity to apply for the job. If I do apply for the job, the fact that that data is retained may disadvantage me in future hiring. Another concern is the 3 V's: the volume, the velocity, and the variety. Right? How quickly everything manipulates, the volume of data that it will have from all of these interviews, all of these resume submissions and cullings and videos and all that sort of thing. A fourth concern is the perpetuation of the status quo, right? We've got a closed loop. AI is using the current employees to develop a job description, which then AI is targeting to particular people that it thinks would meet that job description, which then it evaluates to see if those people that it targeted with its job description created specifically for those type of people is actually right. So it becomes a closed loop. So if you don't want to diversify your company, if you want it to be a bunch of mini-me's, right, just replicating the status quo, then it can be very effective at that. But unfortunately, that raises substantial concerns for people who don't fit in. A fourth point is the notion of cultural fit. A lot of companies are looking for someone who's going to fit in, who's going to blend in and not, stick out as, whoa, who's that and where are they coming from? So the problem with cultural fit, though, is if you're using artificial intelligence technologies to help you figure out who's going to fit in your culture, those technologies are actually going to turn that into a rule. And cultural fit is going to become an actual qualification that it's looking for instead of the more amorphous content or amorphous way that we consider it. You go have a drink with them and see, do you get along? Can you talk about sports or something other than work, right? Those are some of the things that we think about in terms of cultural fit. So those are some of the concerns. Some of the potential solutions are to make sure there's more transparency about these processes and how they're being used, have the vendors disclose to the employers this information, and also just making a better, taking more time, I guess, to really figure out what's going on. So one example of an attempted solution, and I heard Professor Ohm call it toothless, but I don't know if he was referring to this specific one, is New York City. New York City recently adopted an ordinance that mandated 4 basic requirements for employers who are using artificial intelligence technologies in their hiring processes if they are hiring within the city of New York. All right, and so the 4 things are: you have to provide notice that the AI system is being used. You have to give job seekers an opt-out chance. Okay, you also have to have an audit done, an assessment of the effectiveness, if there's any discrepancies based on race or gender or other characteristics. That needs to be a third-party independent audit, and it has to be made public. Your audit results have to be made public. So that seemed like that was going to address all of these issues. It was going to really satisfy a lot of concerns. Some researchers at Cornell did a test, and they sent out students, college students, to go look at all these websites and look at all these ads and try to find the impact assessment, try to find the notice, try to find the opt-out position option. And those students were tasked with, they had 30 minutes to try to do that for each website that they were looking at. And they found 5% of the information being disclosed. Okay, most of them could not find the opt-out provision, or they had to scroll through like 87 web pages. Click on this and then go here and then go here and go here, and then they could find the opt-out position. So again, this was with about 1,000 employers they looked at. So there's more to consider, but I think that's part of the problem. So getting back to Professor Ohm's point about it being toothless, that's kind of what they concluded. While it's helpful because some employers are changing their practices, some of them are saying, forget it, I'm not going to use AI technologies because I don't want to have to go through all these steps. Or we did our assessment and it is biased what we're using, so we don't want to report that out, okay? But the problem is this notion of null compliance. And it was unclear whether or not employers were complying because there was so much discretion in the ordinance. The ordinance said, if you are using these AI technologies and they play a substantial role in your hiring decision. So that's where the wiggle room was. Well, I don't think it's a substantial role, so I'm not going to post it. They also couldn't tell if maybe they had an impact assessment done, but it wasn't ready yet. Or maybe they hadn't found a third-party independent auditor who was qualified to do it. So there were all these reasons why there was so low compliance. We don't know if all of the employers were actually not complying, or if they were just on the road to complying, or felt that in their discretion, they didn't need to include that information. So I think I'll stop there.
Okay, great. Thank you. I wanted to start with a question of my own. So, and this piggybacks off of the conversation we had yesterday when we were talking about AI and bias. I know that there are a number of lawyers in the audience, so if you can speak a little bit to the lawyers and maybe people at law firms who are using AI to select their employees, what are some of the ethical rules? What are some of the professional rules of responsibility that people need to be looking out for so that they are not running afoul of those by using AI in algorithmic hiring?
Yeah, so the Colorado Rule 8.4 of Rules of Professional Conduct addresses this notion that you're not supposed to be in the operation of the practice of law discriminating. And so to the extent that you are aware, now that I've told you, and these, today's events have explained about the potential for bias in using these technologies, that's something that attorneys really need to take a look at. The other things that I talked a little bit about yesterday in terms of the ethical rules or the duty of competence, right? If you're a lawyer and you're using artificial intelligence technologies, then you need to be competent in how you use them and making sure that you understand enough to know what you don't know and what those limitations are. We've already talked about the cost issue, right? You can minimize costs for clients by using these technologies, but you maximize costs if you get sanctioned by using ChatGPT-3 to answer your legal questions instead of 4. So those are a couple of the concerns. Was there more that you wanted me to discuss?
No, thank you. I
Okay.
wanted just the benefit for our law students and those lawyers in the room to have a sense of what those rules are that we need to keep in mind. And we are going to take questions soon. So hang on. Let's have other people react to Professor Goodman's talk, and then we'll open up the floor.
I think I'm just going to continue us on this. What are the benefits versus these very real costs that I'm really worried about? I suspect a lot of this is because we've made applying for a job too easy. Like, we've made it so frictionless through Monster.com and Indeed that every job is now a national job, and you hear about kind of minimum wage jobs that get 10,000 resumes. And so if that's your starting point, you have to use something automated. Right? It would be deeply unfair if you didn't. But I wonder if that's the problem we should be fixing instead. Like, maybe there's something to old-fashioned, having a little bit of friction so that if you're going to apply for a job, it's because you really want that job. Now, I know there are probably impacts on people who are poor and people who are busy and people who have to take care of their children. And so we need to design that into the system. But I think a lot of the problems you're pointing to are because we have 10,000 applications.
Yeah, no, that's a really good point. And I think part of why we have that 10,000 applications is because workforces are trying to diversify and trying to reach out to other
so
groups.
It's,
So if you want to do that,
and uses all the way down.
yeah, and then you have a better shot of finding some more diverse candidates if you have a wider pool. But the other concern, though, is if we tried to go back to the more old-fashioned way, where you research the company by going there and looking at their brochures and physically being there, ChatGPT can write you an amazing cover letter without you having to do any of that.
All right.
So yeah, so
I will say I never do this, but the one word I haven't used today is friction, and a lot of my current work is thinking about how to build more friction into these frictionless systems, but like in exactly the right place to bring about human values that are a deficit. So.
Yeah, and so with some employers, I mean, my son was recently applying for jobs, and he's a software engineer. And so they give you all these tests, like they give you a test, and then a little bit later, another test. And so that, if you really want the job, you keep taking these tests. If you don't, then you move on. But that is, again, a place where those with fewer resources or fewer options, perhaps more diverse candidates, would not make it through all of those rounds.
Chris, it's Chris and Paul, I think. Chris, so like New York, right? Seemed to be a lot about transparency when we talk about notice and audits, et cetera, right? You talked about a lot of ways folks are using data in the employment context. Don't we just really need new norms when we talk about how do we regulate inferences, you know, how we use data, and like what are those new norms? And then let me kind of just press Paul on this, like, don't we need new rules in this context as opposed to just saying, hey, you know, nothing's really new under the sun. We can just use the old rules. Don't we need new rules in this context?
Yeah, so we definitely need new norms, but again, so many employers are so self-interested, right? And not interested in the public good, right? And so if you know that Chris Goodman applied for a job with your firm 2 years ago, you want to go back and look at that information if you still have it, right? Because that's going to help you make a better decision. So I think it would be fantastic if employers were more public-minded and thinking about the privacy implications for employees and the fact that there is this unequal sort of bargaining power when you're applying for a job as opposed to the person who may give you the job. So I think that would be wonderful, but how do we get to that point? Well, maybe we get to that point because of this New York City example, because some employers are saying, forget it, we're gonna do it the old-fashioned way because we're not, either this is biased, now we see it, or we just don't want to put it out there that we're using biased algorithms to, you know, to do our job for us. So incremental change, maybe.
Yeah, it's funny. I do feel like what you were describing was toothless, but it has such a non-toothless response in the story you tell where, you know, companies are walking away from it. So in a funny way, you know, I've already outed the privacy community as, right. I've already outed the privacy community as being a little bit of an echo chamber. But if you want to know the one thing almost every privacy scholar, I'll let you speak for yourself, Scott, agrees on, it's a kind of unified understanding and belief that any regimen built on giving people more information and then making them choose is doomed to fail. That the companies who are regulated in those ways are so sophisticated at presenting the question to you at the worst possible moment. I just want to read this recipe because something's about to boil. Yes, I'll accept all your cookies, right? That's what makes proposals like this like public enemy number one. And I have to do this. The standard citation for that is my good friend Dan Solov, who's got an article on privacy self-management, which is quite good, and I commend it to all of you. Maybe stop reading after that, but yeah, but your story has a twist for me in that a few companies walked away, which is more like a prescriptive rule. Like we're going to make AI so burdensome, right, in a funny way that you might just walk away and not use it. That's a rule. That's an interesting approach. Yeah.
Well, it was a big adjustment when I moved to Switzerland because the default there is no cookies.
Yeah.
Only strictly necessary is collected. And I kept saying, no, I'm gonna choose. And then it was already selected for me that, you know, so I was like, oh, okay, I don't have to choose.
You still get the pop-up though. You still get the annoying
you still get the pop-up, yeah.
But isn't that a little lazy? Like, we're gonna just make it so hard for you as opposed to like grappling with these issues and what are the norms we're gonna come up to regulate?
This isn't ideal. This isn't ideal. No, and that's part two. So the privacy community that's given up on notice and choice, they've uniformly said, we just need to write rules. Like, and we need to write rules, even though some will accuse us of being paternalistic, because frankly, paternalism has embedded within it. Like, we kind of speak on behalf of the society about what we should be doing and not doing. So if that's paternalism, if that's the way you want to define it, then you kind of have to own that label a little bit. But yes, it's about actually deciding these things instead of coming up with procedures and nothing more. Yeah, I agree.
Mm-hmm. Good, okay, thank you so much, and I think we're gonna, go ahead. Yeah. We're gonna open it up to questions, and it is our tradition to take a student question first. So in the back, I have a student way in the back, and if you would go and get us started, thank you.
Hi, thanks for coming, everybody. My name is David, I'm a second-year law student. Quickly realizing that the most efficient way to a third-year law student was paying for ChatGPT, apparently. So, my question is about how we're supposed to handle the fact that data is wielded in spaces that are designed to be manipulative. And I think the most prescient example of this is on social media platforms, right? Twitter makes me mad purposely through the algorithm so that I engage with it, for example. And I think the EU standard is one that came up of it's banning things like cognitive manipulation, but I get worried that that's pretty broad and pretty vague. You know, am I cognitively manipulated when I learn something on Twitter, for example, that I didn't know before? And I guess my question is just how do you see us handling that? Whether that's step 3 turning to a legal reform, or step 3 being a go to tech companies and change their reform. You know, who is the target that tries to address that problem?
So I think the answer is all of the above. And I mean, and this sort of builds on the concept of friction, which is one that, you know, I've talked a little bit about, and that, you know, I think Shoshana Zuboff uses in the end of her book as well, right? Like, absent, you know, robust command and control rules, okay, from a harm reduction standpoint, regulators can create friction for these companies that raise their operating costs, but you individuals can also throw them off your trail. Not imperfectly, but you can confuse them. And this is Helen Nissenbaum and others have written about this in terms of obfuscation, and right. And that involves a cost from the consumer. You have to do work, right? But there are things you can do to make how you are surveilled, tracked, and determined less accurate. And so I would encourage you to try to do those things. Don't be so predictable. And, you know, if you're really a true Luddite, like myself, get off Twitter. And it's not enriching your life. Like, in my view, I've spent plenty of years on it, and I'm happier since leaving. I know Paul's still on there.
Barely, almost never. I've never been on Facebook.
But that would be my view. Is like you know, take the bull by the horns. You know, you use your own engagement with these platforms to try to improve the quality of your life.
So the one thing I'd say is there's an easier test case that's proving why your challenge is so hard. So for the last year, everyone's been obsessed with children, right? So let's be really, literally paternalistic and try and protect our kids from kind of body image problems and addiction. And so a bunch of states are experimenting with proposals to limit, you know, all of these things, and they are being fought and, you know, opposed by not only kind of the people you would expect, but by a bunch of academics who are worried about kind of First Amendment implications. And so if we can't even solve this for children, and as a parent of, you know, freshmen in college, I see every day how like the addiction has taken hold. And even though I tried to be a good parent, I failed in that regard. I would desperately love a law to protect children from some of these effects, and I don't even think we're gonna get there because of the way the fight's unfolding.
In the democracy context, I don't know that there's a bright line. I think that we want politicians to engage with voters of color, for example, rather than suppress their votes in terms of winning. So I like folks trying to engage. So I don't think there's a bright line between political advocacy and kind of like this stealth psychological manipulation. I do think that you can go too far. I think we've got to figure it out. But I think that what a lot of people don't appreciate, because we focus so much on kind of this free market, you know, everything's open thing, is that from the perspective of people of color who have internalized experiences like Indian boarding schools, or being prohibited from speaking Spanish at lunchtime in school, or, you know, Black women who have lost their job because they wear curly hair, you know, this concept of manipulating folk with images really is a continuation of like unfair cultural conquest that violates values of autonomy and expression and association that we say we purport to believe as a liberal democracy. And so I think we've just got to take this seriously, right?
And if I
Thank you.
could just jump in real quick.
Oh, go ahead.
Just one other thing to think about. We look at the EU as an example, but they don't have a First Amendment there. So that really is the difference.
All right, we have a lot of questions, so I'm going to take 3 at a time. So you can get your question out and then ask our panelists to go ahead and take them. So I have this gentleman here, and right here, and then in the way in the back. So those are the three. One right here, two right here, and third in the back. Please ask your question, and then I'll let the panelists respond.
I'll ask my short question instead of the long question. So the quick question is, so the AI auditing standards are really immature right now, but we're still starting to require AI auditing as in New York. So what do we do about that in the meantime? How do we make sure the regulation actually keeps up with the status of what's happening as far as regulation and benchmarking and everything else to keep things safe?
Thank you. The question in the back, can we have somebody? Thank you.
Hi, so this conference is about AI and the Constitution, but I feel like much of the discussion on this panel has been about like state and local level law enforcement and regulations and legislation. So realistically, what role do you see federal regulations playing in protecting these kinds of privacy, given how quickly corporations are developing new technologies? Do you think states should be leading the charge, or are we just going to be subject to the Brussels effect?
Thank you. And one more question right here.
Hi, thank you very much for the panel. I'll try to piggyback on the other questions. We had the Conference of World Affairs recently, and I think it's posted now, but one of the big questions was about cybersecurity and all that sort of thing. And the audience generally was just flabbergasted about how insecure they are with their smartphones or their equipment. And it's almost like going back to the old school stuff, a flip phone, to really get around a lot of those problems. But my question is kind of basically tax off of ethics. And speaking with Harry, it's just a question of quantum computing and nation states, and it's the supercomputers and so on and so forth. So it's this battle going on with information. The information wars are going on. And at some point, speaking with Harry after his lecture, I don't know how to phrase it, but at some point, what this gentleman was saying was about monitoring and how do you keep on top with ethics involved, and Paul Ohm was kind of getting into that as far as the whole ethics and HIPAA. So it's complicated, but it's simple. At some point, is it, like the Hollywood Terminator, the machine's ultimately going to be, for efficiency or whatever the right word is, editing out the ethics. And it was great, the example that was provided with doing the statutes and doing the case law. It's pretty good for AI to do that. But where do you bring in the morality? And again, judges are sworn in on a Bible, not, rules of civil procedure or something like that. So thanks very much. Appreciate it.
We're going to take on, we've got 3 questions on the table. Who wants to take what?
Oh, okay. I can do a little bit on the first 2. So in terms of auditing and assessments, keeping up with the changes in technology and what is going on the federal front, there was recently, a couple of weeks ago, an announcement about the Office of Management and Budget new policy that is going to require, when the federal government is using artificial intelligence technology, so any parts of the federal government, any agencies, they have to make an assessment of, does this impact people's rights and or does it impact people's safety? And if it does, then they're required again to implement these concrete safeguards. They have to have the risk assessment done. And the directive says, if you cannot adopt appropriate safeguards in this circumstance, you must cease using the AI systems. It requires a catalog of all the systems that all the agencies, all the federal agencies are using, and that also will list what are the vulnerabilities, what are the concerns, what are the risks, what are the harms. So that is on those 2 fronts. So I think that will help, because it's not telling you exactly what you have to do. It's based on the risks of harm and what kind of rights are being potentially impacted.
Thank you. Other responses?
On the second question, I think it should be all of the above. Like, I actually just hope Europe saves us from ourselves, and partly because they don't have to contend with our weaponized First Amendment. I mean, it is in AI and the Constitution Conference. The phrase digital Lochner is often used to describe the way the First Amendment has been argued for, not yet embraced, but the Supreme Court will have plenty of opportunities to embrace that. I actually think, and I'm biased because I worked on it, but the state of Colorado's law is extremely significant, and the fact that the legislature continues to be competitive with California, like there's a healthy competition now among the states. And so I just read the headline yesterday in the New York Times that Colorado's added brain scans to the CPA, which I think is like great. And then last but not least, you said something about something called the federal government writing. I don't know what that is. There's another thing that writes statutes? I've never heard of this one. And then lastly, I could go on for hours about ethics. This is something I'm thinking a lot about with the rise of generative AI. Let me just give you the teaser. I think we're going to learn that we don't need the technologists to be the only ethical people. That's been our approach for the last 20 years. We're going to be able to like stick other people other than technologists into these companies, and they could do the heavy lifting on ethics, which I think would be great, right? If we could pull that off.
In terms of the state or federal regulation piece, I think that state, local, and federal entities have, frankly, just there are constitutional problems with all three in terms of like the issues that Professor Skinner-Thompson was talking about here, right? And so I think that this court may not recognize them, but I do think that there are constitutional issues in terms of all three. Right now, very frankly, our federal government is broken in terms of lawmaking. States definitely have a role in terms of getting new ideas out there. We had a conversation yesterday after the panel about this, and hopefully if we have some different states doing some different things, industry will come to the table with academics and public interest folks and say, hey, we need kind of one standard, we need some consistency, we're actually willing to come to the table and compromise so that we can have some uniformity and some clarity and we can get something done. Finally, I'd just like to say, we've had these instances before in terms of innovation and money, cotton gin, and, cotton was our, over half of our exports until 1860 and our leading export until 1932. But obviously there were a lot of costs with cotton in terms of that we're still dealing with in terms of racial equity. Similarly, Industrial Revolution's great. It's the reason we're in this room with these lights and this comfortable environment. But we're dealing with climate issues because the costs were externalized to other folks and law did not step up to the plate here. And so for folks who are law students, I think they're well positioned to build careers to ensure that as this technology emerges, certainly we can have some innovation and some good things come of it, but those harms won't be unfairly externalized onto others so that we're kind of dealing with these large societal problems that we don't even know if we're going to be able to contain.
Thank you so much. I think we all need to be at the table, including us Luddites. So I appreciate the shout out to Luddites being one of them. I am sorry that we don't have time for all of your questions. The good news is we have a lunch break. And so for those of you who I wasn't able to call on, please feel free to address your questions to our panelists during our lunch break. I'm asking you to go to the second floor, and lunch is held in Shadden Commons. So go ahead and proceed to Shadden Commons. There'll be plenty of time to talk more about this topic, and we're going to resume at 1 o'clock here. So please come back at 1. Thank you so much.